In this section, we are covering what is a case brief. A case brief is a tool that we're going to be using in our classroom to be able to condense the information that we are reading on a weekly basis. We will be reading numerous court cases, and the case brief will be a tool that will help you be prepared for lectures and for discussion. In addition, you will be submitting 4 case briefs as assignments during this semester. So let's get started. So when you brief a case, your goal is to reduce the information from the case into a format that will provide you helpful reference for class or just for review and prepping for exams or quizzes. Most importantly, by briefing, okay, when you think of briefing, you think of short, summarized, right? Briefing a case, you will grasp in the case the problem that the court is trying to resolve, or most commonly known as the issue. You are also going to look at the relevant law that the court used to solve it. So either the rule, and we'll go over this a little bit more, how the court applied the rule to the facts, and what is the conclusion. So essentially, it'll give you a little checklist to help you read and understand and also compare cases by being able to go through these elements. So a case brief also typically incorporates the 4 elements of legal reasoning, which we discussed in the previous section. So make sure that you reference those 4 elements of legal reasoning when you're thinking about your case brief. So what you want to do for a case brief, the first step is identification of the actual case. So you want to be able to identify the name of the case, the jurisdiction. We'll learn a little bit more about what is jurisdiction, but essentially what court, level of court is looking at it, jurisdiction in terms of state or federal. And we'll get more into this and you'll get much more comfortable in the coming weeks. Also the date and type of decision, okay? So for example, Roe versus Wade, that is a very common case that was ruled in the Supreme Court in the 1970s, right? Roe versus Wade is the name of the case. Then you'll see an annotation. This annotation is used as a reference to the Supreme Court. US is a reference to the Supreme Court. These numbers are usually the page numbers or chapters where you can find the case if you're looking for it, as it's in the library. And then the date, which is in 1973. That's when the decision was made. I'll give you another example. So for this week, we're looking at Prochnow versus Prochnow, right? That is the name. Prochnow versus Prochnow is the name of the case. Then we have that it was a Supreme Court of Wisconsin, so we know that this is a state case. And this is the annotation that the court references. So it's a citation of where you can locate the opinion. And we know that this was decided in Wisconsin in 1957. So when you're writing your case brief, you want to make sure that you put all this information at the top of your case brief. You will look at the sample that I've provided that is attached in this page and you will see what I'm talking about. Okay, so following the first step, then you have to move on to the elements of a brief. Very simple. If any of you end up going to law school, you will learn this acronym, what is called FIRAC. The facts, the issue, the rule, an analysis, and conclusion. These are all the elements that are incorporated into a brief. Okay, so you start from the very beginning. After you indicate the title of the brief, you move on to the facts. So that's step 2. Facts. You want to identify who are the parties, those that are principally involved. Also, the elements that led to the dispute or the claim. What happened procedurally. So what we will learn in this class is that many cases have been heard by different levels in the court system. They usually start at the lower court. When someone is unhappy with the decision, they appeal it to the Court of Appeals. And then if they're unhappy there, if there's a party that is unhappy, they have the ability to appeal it to the Supreme Court. So sometimes what happens procedurally can also be an important and relevant fact. So you have to be thoughtful about what is relevant in the facts of this case. And what are the facts also that the justice that writes the opinion uses to support the end conclusion? So facts. Step 3, we have the issue. So what is in dispute? What is the court being asked to resolve? That is what you want to get at. The issue generally takes a couple sentences, sometimes one. It's usually a very simple question that they're trying to resolve. Step 4. In step 4, we are looking at the rule. So what source of law will be applied, or others call it the rule of law applied. It could be the Constitution, it could be a statute, it could be a regulation. So make sure that you highlight when you're reading these cases what source of law is going to be applied in the case and the facts. And usually it's pretty obvious, but if you're having trouble, always feel free to ask. Then step 5 is the analysis. This is probably one of the most important steps in your case brief. In this section, you usually have a minimum of a paragraph or a couple paragraphs to help you understand and summarize what were the reasons for the conclusion and how they applied the law. So essentially is what is the significance of the particular facts as the law that they are trying to apply? And are there any other past cases? That matters. If a court annotates or cites a previous case, it's probably an important thing that you need to note in your analysis. So again, this one will usually have a couple different paragraphs. And then step 6 is your final conclusion. So what did the court decide? Who won? Not more than 1 or 2 sentences. So again, step 6, very simple. Conclusion, the court's decision, who won, and very simple in 1 or 2 sentences. If you have any questions, please feel free to send me a little message. So a couple legal terms that I want you guys to keep in mind as you guys are going through the different opinions. So we'll start off with the first one, holding. Then we'll go to concurring opinion. Then we have dissenting opinion or dissent, plurality of opinion, and majority of opinion. So first, holding. The holding, it's a court's resolution of an issue that they have heard. Okay, that is what the holding is. What is a concurrent opinion? Well, a concurrent opinion is a written opinion by either one or more judges of a court which agrees with the decision made by the majority of the court, however, states different reasons for the base of their decision. So, again, concurrent opinion is an opinion by one or more judges that agrees with the outcome, right, of the majority of the court. However, they agree with the outcome for different reasons. Majority opinion. Majority of opinion. An opinion agreed to by more than half of the members of the court. Why do we have a majority opinion? Well, Most appellate cases are heard by a panel of 3 judges. In an appellate case, the majority opinion is at least 2 judges. In the Supreme Court, as we will learn, the Supreme Court has 9 justices. The majority opinion would at minimum have to be, what is the majority of 9? 5, right? But it could also be 6, or it could be 7 or 8. That could be the majority of opinion, but minimum, it has to be 5 if 9 judges voted on the outcome of the opinion. I just mentioned concurring opinion, so we'll repeat it again. When the justice agrees with the outcome, but for different. Dissent. The dissent is an opinion in a legal case that is written, it could be written by 1 judge or 2 judges, depending on who disagrees with the outcome, and they explain the reasons for disagreement. Why is a dissent opinion important? We will learn that a dissent opinion is important because there are times when in history the dissent opinion later becomes the majority opinion. We have seen this happen in previous court cases because of the historical context of the times. And so when we have those dissenting opinions that are critical in our understanding of legal reasoning, we will talk about them. If in any of the cases that you are assigned to read, if you have a dissenting opinion, please make sure to briefly summarize them in your case brief and noting that there was a dissenting opinion. And then we have plurality of opinion of a group of judges, often in the appellate court again, in which no single opinion received the support of the majority of the court. So this means that the majority agreed on the outcome of the case. However, there was not a majority that agreed on the same reasoning in the outcome. Therefore, there are different groups of justices that will write opinions to be able to memorialize their reasons for the outcome. We'll end there.